responsibility. When we broke off, I had shown the court the 2013 pollution prevention control regulations, which are at page 6,200. It's not a full copy of the regulations. There's more to them than this, but these are the regulations that engage the department's functions and allow for the permitting regime for landfill sites, and that's how the regulation occurs from the department's perspective. There was a permit in place for this site. There also was an ongoing management plan, which was in its 10th version, and is an iterative and living document, and which continues to be in place presently. So this site is still subject to permitting and regulation by the department. So the court can see the scheme of the various statute provisions, which we say interlock. The permitting process is for the department. They have enforcement and prohibition powers in respect of that. They can bring forward notices to cease work on the site. They have all the tools that they need to engage. In this case, they did not consider that there was a need for prohibition or intervention or abatement, and that was based on their ongoing engagement with the operator. The second parallel regime allows for local councils to take action, and the first respondent, Lisburn Council, were also of the view that abatement action for nuisance was not necessary in this case, and they didn't take necessary steps. Belfast City Council, who are a council adjacent to the site, the site's not on their territory but adjacent to it, they received pre-action correspondence threatening judicial review, and in response to that they issued an abatement notice and engaged the Part 7 machinery of the Act. So that was the process to set in train litigation by the operator, Alpha. So it's an important contextual feature to this case and to the Court of Appeal's ultimate determination of it, that there was a Part 7 process in train involving the same site, involving the same issue, the same evidence and the same questions of scientific expertise. That was all already before the Magistrates' Court. And indeed that was contested, as many listeners flagged earlier in exchanges with me. The operator brought a judicial review challenge to the abatement notice because they wanted to litigate it in the High Court, and that matter was dealt with by Mr Justice Schofield. I'll refer to that in a moment. So what these pieces of litigation were travelling together. The application by the appellant in this case took the form of a judicial review. You've seen it in its now complicated incarnation. This was a case, however, where there was no permission hearing or leave hearing, as we describe it. The CPR rules, which most of the court will be familiar with, don't apply in Northern Ireland. We don't have the same structured approach to judicial review. And in this case, the judge dealt with the matter on the papers and granted leave on the papers. So one of the issues that looms large, usually in debates about alternative remedy discretion in cases of this nature, is whether it's a leave stage question, and really can you come back to it. In this case, no opportunity was available for the issue to be raised at the leave stage because we didn't have a leave hearing. The judge granted leave on the papers. And you have his order, which is in the electronic bundle at page 262 and 263. He was alive to the possibility of alternative remedy issues. You'll see that in paragraph 2 of the actual order on page 263. He declined the interim relief application. So you've seen the applicant was seeking interim relief initially on the papers, and he said if any such applications to be pursued should be made on notice to the respondents and the operator. Any application would require to address the question of why damages in a private law action would not be an adequate remedy, the balance of convenience, impact on the operators, cross undertakings and so forth. So the matter was put back to the applicant to consider whether or not they wanted to pursue that, and you'll see from the Order 53 statement that the interim relief application was then abandoned. So the applicant no longer sought that, so that point disappeared. However, both the councils involved, Belfast Council and Lisburn Council, had flagged in their responses to pre-action correspondence that Section 70 of the 2011 Act provided an alternative remedy. I'll give you the references for that. Belfast City Council said that in their response on the 27th of April. That's at page 884. And Lisburn Council said that in correspondence of the 25th of June, page 343. So both the local authorities were flagging, prior to permission being granted in the case, that there was an alternative route to be taken. And the department, who I represent, didn't take the point. In fact, their pre-action response didn't issue until after leave had been granted, so the matter wasn't before the court from the department's perspective. But as the litigation unfolded, and the court can see this from the history which we set out in our skeleton argument, the Alpha application was heard by Mr Justice Schofield. The appellant took the alternative remedy point against Alpha. So the issue of whether Part 7 was the appropriate arena for these matters was very much in play, and the appellant was contending for it. In response to that, the department corresponded with the appellant and invited them again to consider whether or not Section 70 was an appropriate route for this litigation. And that was done because it was plain by that stage, and the appellant had made an application to adduce a significant quantity of expert evidence, that we were going to have a judicial review with contested scientific evidence, and the court will know judicial review is ill-suited to evidence of that nature. So again, that was one of the reasons why the appellant was encouraged to consider an alternative approach. That was eschewed by the appellant. Mr Justice Schofield gave his judgment on the 29th of December 2021, finding that Alpha should bring their proceedings or conduct their proceedings through the Part 7 route. So the alternative remedy argument there prevailed. That led the department to bring a set-aside application, so to set aside the grant of leave, and the set-aside application was grounded on the route available through Section 70. So that's how the issue came to be a live issue in the proceedings. The argument advanced in support of the set-aside application. You can find it, you need to go to it, page 347 to 361. The case was being made that this would be a more efficacious remedy for the applicant in a form that was best suited to resolve disputes of expert evidence, and that the applicant had selected an unnecessarily circuitous route to obtain her primary objective of abating the nuisance. That was the case that was being made. The matter came before Mr Justice Humphreys, and on the set-aside application, he raised some other authorities, and the department decided to withdraw the set-aside application on the basis that the matter be dealt with at the substantive hearing. So that's how the alternative remedy issue factored into the litigation at that juncture. The judgment of Mr Justice Humphreys deals with the point at page 259 to 260. At this stage, he'd already dismissed the human rights claim, so he'd considered that to be unmeritorious, and I've already flagged to you his line on the argument about limits, which was that there was no basis for that argument. So he dealt with alternative remedy from 86 through to 93, and the approach he took is perhaps clearly illustrated at 91 and 92. He noted that it should have been addressed at the leave stage. We dispute that, but I've explained why. And then he said it concerned public law issues of regulation and enforcement. There's an obvious overlap between the two questions. The litigations have species of litigation of different purposes. His view was a member of the public with sufficient interest entitled to hold regulators to account by pursuing any public law wrongdoing. It would be an unfortunate and unattractive position if a regulator could effectively be immune from suit in this sphere by reference to alternative proceedings in the Magistrates' Court. We say that's not quite the case we were making, or are making, or made to the Court of Appeal.
Where are you reading from?
This is page 260, my Lord, paragraph 92.
92, thank you.
Mr Justice Humphreys' key findings on alternative remedy. It's not an argument about immunity from suit. It's an argument about discretion and case management. And in a context where there are already extant Part 7 proceedings on exactly the same issue in the Magistrates' Court, our contention was that's the more efficacious route to address the true issue that's concerning the applicant, which was the abatement of the nuisance which she had complained about. So we weren't contending for immunity from suit on the part of the department, but we were saying, looked at contextually, this was the better approach for this case, and indeed we say and remain of the view that it aligns with the overall statutory structure, which allows for these issues of some complexity to be determined in a court that has a proper role in terms of fact-finding and addressing contested evidence.
But it would only address the conduct of the private operator. It wouldn't address conduct alleged to have been unlawful by any of the respondents.
I accept that. It doesn't address the specific forms of relief for conduct in respect of the public authorities.
Well, more than relief, it doesn't address whether they have breached their public law, regulatory and enforcement duties.
No, I agree.
So how is it an alternative remedy?
Well, the issue of the manner in which the public authorities have addressed the nuisance will have to be dealt with in the Part 7 abatement proceedings brought by Belfast City Council, because if they move to prosecute, the department have to get involved in that. They either consent to the prosecution and we move into debate about whether best alternative techniques have been used. So
Sorry, I thought we were talking about an application by this appellant.
Yes, I agree. This appellant.
How is a Section 70 abatement notice application as a person aggrieved going to address the public law responsibilities of your clients and the other respondents?
It won't address that in full. I don't.
Well, it won't address it at all, will it?
Well, whether or not there may be other means by which that can be addressed, and the Court of Appeal alluded to that. Matters being raised with the Ombudsman about the approach the
that
Department
depends
have
on
taken.
maladministration, doesn't it?
It does, yes.
And that's not what this case is about.
No,
So how are these alternative remedies?
well, they may not be alternative remedies.
No.
But I'm suggesting that the matter can be viewed from a slightly wider panorama of general discretion on the part of the court managing public law proceedings. Because what we must be astute to is the manner in which applicants choose to cast their case in order to have it heard in a particular forum. You could cast this case straightforwardly as a nuisance case, which really was, we say, the origins of it.
But that would just be against the operator.
Yes.
That wouldn't be seeking to hold the public authorities to their legal obligations.
Yes. Again, I accept it doesn't catch that point, but in this case, the public authority operators were engaged in ongoing monitoring and compliance. It was a live and iterative process, which could be addressed if it emerged that there was a serious defect or fault through either the abatement proceedings brought by Belfast or by Section 70 proceedings brought by a claimant. So it's not the case that there's an immunity that emerges for the department. The department's still subject to scrutiny and challenge if appropriate. But in the overall context of this case, it was being argued that because of the way it unfolded, the fact that it was already there in the district and the Magistrates Court under the Belfast proceedings, these proceedings should be brought into the same court and dealt with together. That's a matter of case management, which would.
And just one other thing. I mean, here there was the Article 8 claim, including its historic dimension going back over time. In a Section 70 abatement claim, could an individual get damages for a nuisance that had existed over a period of time?
I think they may have to bring separate civil proceedings in respect of that.
Right.
They'd have to bring two sets of proceedings instead of the one set.
Well, possibly.
Judicial review proceedings.
Well, there's always a question as to whether or not damages will be awarded in judicial review proceedings anyway. That part may be hived off and dealt with separately, but I accept that you may end up with some duplication there.
Because there isn't any scope for compensation under the Act, is there? You only get your expenses for bringing the proceeding.
Yes.
That's it.
You can bring separate civil proceedings, which is what Mr. Schofield was alluding to.
Yeah.
And he essentially was dealing with that if the applicant was pursuing the matter urgently by way of interim relief, and the applicant stepped away from that.
So could I can't resist the temptation, Dr. McAleenon, of inquiring what has happened? What has happened to the appeal brought by Alpha, and how was it disposed of?
Belfast City Council withdrew the abatement notice. And
I thought you said that the two sets of proceedings allied with each other would provide some sort of remedy.
Well, they were at that time. These are relatively recently withdrawn. Again, this reflects the academic nature of the case, because Belfast City Council no longer pursue the abatement, Alpha no longer pursue the appeal. That may well reflect the fact that the issue of nuisance has dissipated. But at the point in time when these matters are being debated, and this case has now gone on for some 3 years, when it was apparently critical in May, June, July 2021, then there was an opportunity for the matter to be managed in a way that had these separate sets of proceedings aligned in the court, we would say, best placed to grapple with the true issue. I accept.
And tell me something, does case management result in a litigant not being able to advance a case against a public authority to make sure it's complying with its duties?
Well, as my Lord knows, there are many levers available to the court. The court could adjourn the public law proceedings, could adjourn the judicial review pending the conclusion of the Part 7, Section 70 proceedings. It would appear to me to be a pragmatic and sensible way to deal with it, and that no one loses anything in that context. So there are, we say, all the tools available to ensure that the most efficacious route is chosen to deal with litigation. And the problem we see here, and it's actually reflected in Richards as well, is a hollowing out of the Part 7 type scheme. Judicial review has become the first resort for cases of this nature, not the last resort. So, stepping back...
Is that really right?
Well...
Because what's being said is that the Council and the Department have not been operating the Part 7 regime as they should have done.
Well,
so it's not. It might be said it's not hollowing it out. It's trying to give it content and make sure that it works properly.
Well, the Part 7 regime links to the PPC regime, which is operating. That's the permitting scheme. So our submission is these schemes ought to be allowed to operate to their limits, and only when they're not able to deliver will the public law safeguard come into play. There's clearly been a tendency. Richards is another example. You'll see very little treatment of the equivalent regime in the Richards litigation. The Court of Appeal alludes to it at paragraph 9 of the judgment, but it's not a focus. It's not referenced really at all in the first instance proceedings. And this goes back to a point dealt with in Glencore. Sometimes it's worth stepping back to see, well, what did Parliament intend in terms of the regulation of this field? And Parliament clearly intended that we would have these interlocking statutory schemes used to their maximum. And when they reached their limits and couldn't deliver more, then judicial review is available. We haven't really argued against that.
But if you say used to their maximum, the complaint here is they weren't being used to their maximum. They weren't being used properly at all. That's the complaint.
Well, that's the complaint. And the answer, well, the answer...
So I'm just questioning the logic of what you're saying about let the scheme work first and then go to judicial review. Why is judicial review excluded if the scheme isn't being operated properly in the first place?
Well, it's not excluded, my Lord. I'm not contending for it being excluded, but...
All right, and then I go back to the point, the complaint here, whatever its merits, the complaint was that the scheme was not being operated properly, whether it be the Part 7 scheme with the Council or the permitting scheme for the second and third respondents. Yes. That was the complaint.
Yes. Well, what I venture is a way to deal with that, where you have what we had in this case, a great deal of technical evidence and complexity about the limits and parts per billion, etc., is allow for those issues to be dealt with in the Part 7 proceedings, either let the Alpha case run or a Section 70 case alongside it, run the two together. And if it emerges out of that there's plainly a nuisance problem, then the regulator can be held to account through the public law proceedings.
I mean, if I may say so, I find that logic a little bit hard to follow, because you've referred to the desirability of having the expert evidence, if you like, sorted out, reviewed and resolved by a court in the Part 7 proceedings. But if one's going down the judicial review route, you wouldn't have a contest of expert evidence that needed to be resolved with witnesses going into the witness box and so on. You would be looking purely at it from the point of view of the public authority, whether they got sufficient information to justify whatever decision that had been taken. So I'm not sure there that it's a fair comparison if you're looking at what you're trying to get out of a judicial review claim. You're looking to check whether the decision-making process of the public authority has been carried out properly. Whereas if you're in a Section 70 set of abatement proceedings, in effect, I assume that what happens is the operator comes forward with their experts and says, well, we are using best available technologies, therefore we have a defence, and then you do get the need for experts to go into the witness box, I assume, for that to be resolved. But you don't need to do that in a judicial review, I wouldn't have thought.
Well, it can be done in judicial review. It ought not to be. It's not an appropriate vehicle for it.
As you say, it ought not to be, because that would be a misconception of what judicial review is there to sort out, wouldn't it?
Yes, but equally one sees in this case that what emerges is you have a conflict of technical evidence, which, as the Court of Appeal noted, is resolved in favour of the respondent because of the rules of evidence that apply. Therefore, we have a slightly hollow exercise in respect of that. The applicant won't succeed in the judicial review, and there's a better place for him for those points to be tested. That's the argument there, and that should have been allowed to run its course. That's what one loses by focusing on the judicial review. The other point we make, of course, is, and stepping back again in this case and looking at Richards and the human rights argument that was behind the case, it's not at all clear that there was ever going to be a remedy in public law proceedings for this applicant because of what Richards said, because of the evidence about no guidance limit. So if the applicant was going to take this matter forward and meet her concern, then Section 70 route seemed to be actually a better, or maybe the only, means of redress for her, looking at it from her perspective. So those are the arguments which the judge rejected in first instance, and he found against us.
Sorry, Dr. McAleenon, could I just bring you back to something I thought I heard you say, and that is that you were asked, why is judicial review excluded? You said, you're not saying that it is excluded.
Yes.
Did I hear you correctly?
Yes. We're not arguing for Oyster.
Well, the outcome of the Court of Appeal's decision is that judicial review is excluded.
Well, that's the view the Court of Appeal took in their approach to the.
Well, I mean, are you supporting that outcome? Are you saying judicial review is excluded?
We're not.
I heard you. If I heard you correctly, you were saying it's not.
We're not contending for the ouster of judicial review. We're saying that in the exercise of a court's discretion and this court's discretion, it could have and did reach a proper view that the alternative approaches should have been exhausted. That's what the court. They allowed our cross appeal on that point. They dealt relatively lightly with the merits of the appeal.
And did you, during the course of that cross appeal, contend that or was there any submission made to the Court of Appeal in relation to the powers of the Ombudsman? Did you rely upon that, or were there any submissions about it?
We didn't make that case, Lord, and we haven't.
And are you making that case today?
No, I raised it in exchanges because it's something the Court of Appeal made. We didn't make the positive case.
I just wanted to know what your case is.
No, well,
are you making it today?
No, Lord. No. We recognise the limitations in the Ombudsman's jurisdiction,
And are you also? I understood your argument to be based upon Section 70. Are you making a case that civil proceedings are an adequate alternative remedy?
Well, they are an alternative remedy, and they can deliver.
Are you making a case that the judicial review proceedings should not be allowed to proceed on the basis of the alternative remedy of civil proceedings?
We didn't make that case in the Court of Appeal, my Lord.
And do you make it now, today?
I only make it in this way, my Lord. In terms of a composite approach, Section 70 can deliver a certain amount for an applicant. If they're truly pursuing historic damages, then a civil claim may provide a vehicle for that. And I'm recognising that as a fact of the overall scheme. But we didn't advance that argument. The Court of Appeal took the course that it did. It clearly did so influenced by its own consideration of the Alpha litigation. So the Court of Appeal is looking at the overall management of landfill litigation in respect of this site. And informed by what had happened in the Alpha case, it prioritised the alternative remedy dimension of the appeal. And we say it didn't fall into legal error in doing that. It was a matter within its discretion. So we're not making a jurisdictional argument. We're not talking about ouster clauses or anything of that nature. In the context.
Can I just pick you up on part of your answer to Lord Stevens, where you said, if damages are sought, a civil case can meet that.
Yes.
But it won't with it, because if you're seeking damages for breach of Article 8, you're seeking it from a public authority. it'll be in a different amount and from a different person than would be common law, a common law civil claim for nuisance. And there's always the possibility that the private defendant might be insolvent, or all sorts of things could happen to them so that they can't meet a claim. So it's not as though it's an inevitable function of, even if you could get a civil nuisance claim to stick, that you get any money out of it, quite apart from the cost and difficulty of bringing one.
Yes, I think I'm disposed to accept that there are difficulties, significant difficulties in that regard as well.
So I was left slightly unclear quite what your case was about the relevance of a civil claim in nuisance when one's considering adequate alternative remedy. You seem to be accepting the points I'm putting to you, that it's not an adequate alternative remedy.
As against the department?
Yeah.
Yeah, no, but it's a remedy against the polluter,
Yeah.
Against the landfill operator.
Right.
So, and it's not clear, well,
So I'm so sorry to press you on this, but I do need to understand. You're now emphasising that it's not a remedy against the department. So in what sense does one even try to take it into account as part of the picture, whether there is an adequate alternative remedy as against the department?
well, I think stepping back from what the appellant starts litigation for, she starts litigation to stop the nuisance. That's her primary objective, it seems. She's seeking injunctive relief, possibly to stop that. She refers to possible damages. She can obtain that through civil proceedings against the landfill operator.
But isn't the difficulty with that any person who wishes a regulator to regulate also has another motive, and that is they wish to bring the nuisance to an end. So to say that she has a motive of wishing to bring the nuisance to an end is straightforward, but it doesn't answer the question. And that is that she wishes the regulator to actually carry out its lawful functions. And the alternative remedy you're putting forward does not provide that.
Well, I think I've probably accepted a number of those propositions.
Yes. But do you accept the first one? That is that every single person who makes a complaint about a regulator also has as an underlying motive a desire to bring the nuisance to an end.
Well, I'm not sure it goes as far as accepting all of that. I'm not sure what the motives are of those who bring some of these proceedings. But
I had some difficulties with the Court of Appeals.
It's paragraph 60.
Paragraph 60, is it? Yes. Yeah, but it was also, sorry. Let's see. Yes. No. On our reading of the papers, they don't descend to any detail as to how our reading of the papers leads them to the conclusion that she primarily wanted to prevent noxious fumes. I'm sure she did want to prevent noxious fumes, but and how they came to the factual conclusion on a reading of the papers that it was a mere excuse to commence more complex judicial review proceedings. Whereabouts do you find? Sorry, where's the explanation for those findings?
Well, my Lord, I don't think you'll find them in any of our written submissions.
Yeah.
It's not a case.
I mean, you're not making the case, are you, that this was being used as a convenient excuse to commence more complex judicial review proceedings?
No.
Because if you are, I'd like to know how you do so.
No, I'm not, Lord.
No. Okay.
Our preference would have been for the Court of Appeal to deal with the convention arguments on the merits. That's what we were ready to argue. And if that had happened, then we would be in a position where the alternative remedy issue would be entirely secondary and informed, we would say, by a failure of the Article 8 case. And these interesting discussions about whether damages would be possible or not would fall away. So it's...
perhaps you might have slowed them down a bit.
Well, Lord, it's... we lodged the respondent's notice and put the matter in play. Had we not, then the Court of Appeal would have dealt with the issue on the Article 8 question and we would have had a clean answer on that point. So it's unfortunate that it has unfolded in the way that it has. But again, we say nothing doctrinally wrong with it, looked at contextually. But the obverse is also of interest. We have today debated some of the convention points and the obvious frailty in the convention case. So we say this is a case that was never going to succeed on the Richards type argument. And the analysis and alternative remedy has to be read in that context. We also say that this is a matter that is now entirely academic, and that sounds on what this court does with the case. And I'm conscious I'm cutting a little bit into Mr. Call's time, but I will say this, that and I've already alluded to it, the abatement proceedings by Belfast have been withdrawn. The appeal against that by Alpha has been withdrawn. We've filed supplemental affidavit evidence just before the court in the form of an affidavit from Mr. Miller, which identifies that the site was capped in November 22. There has never been a complaint by this appellant, ever, to the department about it, but the history of complaints is recorded at paragraph 4 of his affidavit. That's page 11 of the supplementary bundle. And you will see that in the last 12 months, there have been only 2 complaints about odour, neither of which were substantiated by NIEA. So a year has passed, 2 complaints in respect of odour. This is a regular barometer for the department and the agency to consider these issues, and nothing has emerged, nothing of substance. And the same is true of Lisburn Council, who have also filed an affidavit indicating that they've, I think, received 3 complaints, none of those substantiated either. So we have
where you say there have been only 2 odour complaints, do you mean only 2 odour complaints to the department?
Yes.
One has to look at that in the light of the fact that this applicant didn't complain to the department at all and yet appeared to have had a real complaint.
Yes, well, this applicant...
Not everyone seems to beat a path to the department's door.
No, but it's some kind of indicator of whether or not there's an ongoing problem, imperfect as it seems, but it's a valuable tool. And you will see, if one looks back, there's affidavit evidence historically about this case. When the site was operational, there were very significant numbers of complaints. And this goes to support our point that this issue has, it would appear in terms of odour, resolved, and for that reason we say the matter is academic. It's a capped site.
What about the historic complaints?
Yes, well, that's the historic complaints can give rise to potential civil claims if anyone wishes to pursue those.
Not against the public authorities?
No, not unless someone makes good an Article 8 claim, which we say, for the reasons I've already gone through, is unlikely to be sustainable. And we have the High Court ruling in our favour. We have Richards in our favour, and we say that's where that matter goes. So, Lords and Lady, I've run over time slightly, and I'm conscious of Mr. Cole will want to deal with some of these issues himself on behalf of the Council, but those are our submissions.
Thank you, Mr. McAleenon. Do you have any further questions? Sure. Mr. Stevens? Any further questions for Mr. McAleenon? Thank you very much. Thank you, Mr. McAleenon.
Yes, no further questions. Thank you.
I'm just going to try to get some of the furniture moved momentarily.
Yes, of course.
Yeah, just thank you. That's okay. So, thank you. Hopefully, I can be heard by Lord Stevens as well.
Mr. Cull, I have no difficulty in hearing you, as ever. Thank you very much indeed.
So, Just to try to set out what I might try to achieve in this afternoon's submission with some opening remarks. We respectfully say this appeal essentially operates in the context of a pragmatic and common sense decision by the Court of Appeal on the availability in the circumstances, and we really want to place emphasis on those words, in the circumstances, of a suitable alternative remedy to the appellant's judicial review challenge to the respondents as regulators. Far from being the outworkings of some form of apostasy of approach, we say the Court of Appeal's decision is very much within principle, and it's not devoid of or contrary to precedent. In fact, it is in some respects an orthodox decision, taking account, as my learned friend Dr. McAleenon has put it, its case management type part. It's, in other words, it's a decision that's within zone. And as I've said, at heart it is a highly fact-sensitive decision. Effective alternative remedy will often, if not always, have to be gauged against sufficiency. And here the Court of Appeal has properly sought to identify the real mischief at hand in order in turn to gauge the most effective means of achieving the adequate addressing of that mischief with direct and desired result. It's cutting through what potentially could be the noise or delay, extra expense of a purported challenge to an intermediate or inflection point, and instead seeks to arrive at the end terminus more directly, with the additional benefit of doing so in a way that actually attaches itself more closely to the statutory scheme carefully constructed for us to operate by the Northern Ireland Assembly. So I want to try to adopt primarily a three-limbed approach to my submissions this afternoon. Firstly, I just want to set some factual backdrop from our perspective. And I'm conscious the Court has already spent some time on that today. I'll try to do that as quickly as possible. I then want to try to draw out and identify some of the key legal principles on alternative remedy from some of the case law. And then to look to the interplay between those facts and the principles to illustrate the orthodoxy of the Court of Appeal's approach and how, in fact, it doesn't give rise to what might be described as the ominous portent that the appellant paints for the rule of law and accountability, particularly for my clients, the first respondent, in the discharge of its statutory duty under the 2011 Act. And that will involve, I think, having to look briefly at what the courts below have said about the actions of my clients, but also how that fits in with the Section 70 process. And our friend Dr. McAleenon has taken you to that, so we'll do that hopefully reasonably quickly as well. Could I ask then the Court to turn within the core bundle to page 317 of the electronic pages. And this is in the first affidavit of the appellant, Ms. McAleenon. And in particular, if I could ask the Court to turn to paragraph 6 of her affidavit. And she says as follows: I contacted my instructed solicitors about the effects of the odour carried by the omissions from Mulligas landfill site on the 25th of January 2021 after seeing a media article which advised that they had initiated legal proceedings in which we intend on seeking damages by way of compensation for those residents affected by this ongoing odour. Because I too had been affected by the ongoing odour carried by these emissions. And we respectfully suggest to the Court that even there, at that very opening gambit from the applicant, we can see essentially that the main issue for her is the addressing of the odour and the obtaining of compensation for the impact that it has had upon her. It is archetypally the common or garden. I don't mean to minimise the impact of it, but it is nothing unusual that somebody receiving a nuisance of that nature at their home residence would take a step that would address itself directly to the nuisance. So the main concern or mischief from that opening gambit we can see is the nuisance itself, and the thing that attracts our attention to the potential of legal proceedings at the earliest stage is actually going right to the nub of that. It's going to the nuisance itself, not going to what the regulators might be doing to consider the nuisance. Similarly,
she might also like the nuisance to stop, and in order to do so, she might like the regulators to comply with their public law duties.
well,
And the idea that you receive compensation for past being exposed to a nuisance doesn't hold her up as being incorrect or not worthy of belief or whatever.
no,
It is quite simply one of the motivations. She wanted to get damages
yes,
for having her home invaded by a noxious odour on her case.
yes, well, to be clear, I'm certainly not trying to suggest that Ms McAleenon or anybody in her situation could be subject to criticism or to consider that she's doing something wrong. That's not really the issue here. The issue, as we'll come to in due course, is primarily a question for the court receiving the eventual litigation that arises as to whether and how it sees that matter moving forward for determination. And in this case, as we'll see, and as the court knows, the Court of Appeal's considered view on the matter was that the judicial review was in large measure a distraction, and that actually the real issue here was the nuisance, and that the appropriate allocation of judicial resources, etc., in the exercise of its discretion in the consideration of how to move forward with the matter, was that the matter should be dealt with either by way of the Section 70 process or by civil proceedings. But we then see, if we turn to page 833, which is in Appendix 2 at Section 7, Romans 1. And I'm conscious of the time that's available to. I'm not going to be taking the court through swathes of evidence of this nature, but it's just to give the court a feel for the type of approach that was being adopted at the earliest outset, either by the...
Is this the pre-action letter?
This is the pre-action letter, but interestingly, lady, it's important to point out and be clear, it's not, I think, directly a pre-action letter on the part of the appellant. Oh. This is a letter dated the 8th of January 2021, and it's from the appellant's solicitors, but it would appear to be in relation to a third party, but in the same context of odour from Mulla Glass. So in that, and you can see therefore there are various redactions in that document protecting the privacy of that individual, no issues taken with that. The letter itself, I would ask the court to consider it at some length. I'm not going to take the court through all of it, but it's clear that it's very much the traditional nuisance type claim.
But it's not her pre-action letter.
No, I'll come to that later. Yes, indeed, yes. But this it's setting the wider context within which eventually the Court of Appeal comes to the decision that it did. That's obviously before the court today. So the genesis of the complaint is again in that traditional setting of a nuisance complaint, seeking compensation, and indeed, I suppose, by inflection or by implication, potentially injunction and injunctive relief to prevent similar difficulties in the future. So we can see that in particular at paragraph 17 on page 838, where in fact the letter refers as follows to, in accordance with the pre-action protocol for civil litigation, we now request you provide us the details of your insurer, etc. And then at paragraph 20, we can see the letter has what comes close to or purports to be effectively a bullet letter type aspect to it. And if I can then, in the same bundle, ask the court to turn to page 711. The court can see a further letter dated 20 days later, 28th of January 2021, again from the appellant solicitors, but not categorically stated as being on behalf of the appellant. It's not clear whether it's put forward on that basis, because it's a more general point and not naming any specific applicant. Paragraph 8.
So again, it's not a letter on behalf of the appellant, is that right?
Well, I'm afraid, Lord, I think I'd have to say I don't know whether it is or not. It seems a strange thing to have to say to the court, but it's not really clear. But what is clear, it's from the appellant's solicitors, and paragraph 8, you can see, this is, stress the date again, 20th of January 2021. Paragraph 8 on page 714 reads as follows. Section 70 states that a court of summary jurisdiction may act on a complaint made by any person who is aggrieved by the existence of a statutory nuisance, and that the court shall order the nuisance be abated and its recurrence be prohibited. So, again, one can see at this stage reference being made to the alternatives to judicial review.
They're flagging that up, but they're not saying we're going to do that. They're saying you should do it.
Well,
ask that you initiate summary proceedings.
Indeed, and I appreciate really that it's perhaps at an early stage, but it's interesting. We respectfully say that the consideration has been given to Section 70. Now, actually, of course, it would seem unlikely that the council itself would be in a position to bring a claim under Section 70. There are other powers in Part 7 that attach itself to the council by way of an abatement notice, but the Section 70 power is really for somebody who is effectively suffering the statutory nuisance more directly. And it would seem unclear, again, at this stage, whether there was something akin to an inability or an error in being able to understand that Section 70 is available to the appellant or somebody in the appellant's position, even if it's not specifically relating to her. So there may be a misconception as to who can or should exercise the Section 70 power. And then...
but, I mean, sorry, might it not be said that the basic thrust of this letter is clear? The appellant wants the odours to stop,
yes,
not unreasonably, and she's asking the council, please fulfil your responsibilities as a public authority to make it stop.
Yes, Lord, I appreciate that the letter has that connotation, and the only point I'm really drawing out from it is that the Section 70 point is specifically referred to. So there's, at an early stage, there is a recognition of Section 70, there is an understanding of its availability. There may be some misconception about who can operate it, but a reading of the section itself would resolve that rather quickly, one would think. So I'm not trying to put this factual backdrop forward on the basis that judicial review was something that simply slipped in by accident. I mean, clearly the appellant has consciously and deliberately decided to go down the route of seeking to have the nuisance dealt with through the regulatory route, and then when the regulatory route wasn't working to her satisfaction, of seeking to challenge the regulator, being my client and Dr. McAleenon's client. And I think in common with Dr. McAleenon's submissions earlier, my client doesn't attempt to suggest to the court that dogmatically that's something that could never be done. Clearly, judicial review is a potential means by which an appellant such as this appellant might try to take forward her problem. really our point in, and it's probably in common with my learned friend's submission on this, is that when the Court of Appeal considered whether that was the way to deal with this in terms of a suitable alternative remedy, it was satisfied there was a suitable alternative remedy through Section 70 and or civil proceedings. And whenever we come to look to what the Court of Appeal said, hopefully reasonably briefly, I'll try to draw that out in a little bit more detail as to why that was an acceptable decision for the Court of Appeal to make on the facts of this case and within the confines of its remit, even though it has the effect, as has been pointed out, of essentially ending the judicial review that the appellant wanted to bring without a direct replacement for it.
And what do you define, Mr. Cole, what do you define as her problem?
I'm sorry, Laura, I just didn't hear the end of that question.
Sorry. You said that judicial review is a potential means by which the appellant could take forward her problem.
Yes.
What is her problem which can be taken forward in a judicial review proceedings?
Well, Lord, I think that's to encapsulate the very nub of the issue here in the way that the Court of Appeal addressed the matter, because what the Court of Appeal has said is that the real issue here is the nuisance, and that the most effective way of dealing with that is to go straight in a direct way through Section 70 and or civil proceedings, and that the judicial review route, while not being closed down as an option in every case of this nature forever and a day in some kind of unspoken oyster clause type way, that actually on the facts of this case, the reality of the situation is that the Section 70 route was a more appropriate way forward. So the problem, the appellant's problem was the nuisance, and the solution to it, the Court of Appeal in its usual incisive fashion has identified and considered should be dealt with differently than the way the appellant has sought to deal with them.
And you don't define her problem in judicial review as being the failure of the regulator to act in accordance with the law. You define her problem as being nuisance.
Sorry, Maureen.
I understand you as defining her problem as being the nuisance,
Yes,
but not the unlawful conduct, the potential unlawful conduct of the regulator, which is usually the target in judicial review proceedings.
yes, Maureen, that's right. It is usually the target in a judicial review, but really the point that we make to this court, arising from the Court of Appeal's decision on this, is one has to stand back and look at the overall picture in a holistic way, and actually in the exercise of the judicial discretion as to whether to entertain the judicial review and in due course as an outcome of that to determine the applicability of any remedy in judicial review, that the Court of Appeal is effectively saying that the courts are quite entitled to see what is the most efficacious way of dealing with the actual real problem here, not the intermediate or inflection problem, which is how the public authorities have dealt with the matter in the exercise of their statutory duty.
So just to be clear, Mr. Southey's proposition is that there are two questions, and that the first question that must be asked is there an alternative remedy, a suitable alternative remedy? And it's only if there is that you get to questions of discretion and what's the most efficacious route to resolve these problems. Do you accept that, or do you say it's a pure discretionary exercise, you don't need to decide?
We say it's the latter, milady.
It's the latter.
It's the latter, because the court is in exercising its discretion as to what's the most efficacious route to the end outcome. So in one sense, while we say the real problem that the appellant has is the odour, the nuisance, I don't think that she or her representatives would disagree. That is, the end outcome is to have the odour removed, dealt with, that issue expunged, and potentially for compensation for past experience of it. And effectively all the Court of Appeal has done if I can use that phrase, all it is done advisedly, because we've ended up in the Supreme Court on this point, and therefore, obviously, there is an issue to be addressed. I'm not trying to minimise it. But what the Court of Appeal has done is, in the exercise of its discretion, to consider what's the best way of getting to that end outcome. It is the end outcome that the applicant or the appellant seeks. It's just a question of the route and the vehicle to get to it. So in that sense, we say that there's no unorthodoxy in that regard, and that the court, judicial review courts, it's a daily fact of life in the judicial review courts that judges will be making decisions in the exercise of discretion on all kinds of grounds that will impact on whether, in fact, the judicial review is going to survive or not. So, for example, there may be issues where there's been delay, and the judicial review court will have to consider whether to extend time in the exercise of its discretion. If it doesn't, then whatever the underlying merits of the case might be, that would be the end of it. Similarly, if one comes to the remedy stage and there's an issue to consider about the impact of any particular remedy on third parties, for example, and their rights, it may be that the court would refrain from any particular type of relief in the exercise of its discretion. There may be issues, and I hasten to add, I'm not suggesting this is the situation here, but it's by way of analogy, comparison. There may be situations where the behaviour of the applicant for judicial review, the hypothetical applicant for judicial review, while they may have a good judicial review point, it may be that their behaviour in some form, how they've gone about it, or some extraneous factor, may be such that the court takes the view that in the exercise of discretion, it's not going to grant the relief that it seeks. So these are not, in that sense, unorthodox situations. These are daily, as I put it, daily facts of life in the Judicial Review Court in this city, in Belfast, elsewhere. And all that the Court of Appeal has done in this case is to exercise that discretion as to what is the way forward in this case. And as part of the exercise of the discretion, it has considered that the Section 70 route and or civil proceedings is a suitable alternative remedy. It's not necessarily an exact carbon copy. It doesn't necessarily have to cover every exact same issue. But in the overall interests of justice and in looking to what the appellant is seeking to achieve, the question the Court of Appeal asked itself, in essence, was what's the right vehicle for achieving that end outcome in the most efficient and efficacious way? And in the exercise of its discretion, it came to the conclusion that it did. So it's not breaking new ground. It's not saying that in every single case of this type or in this field, that judicial review forever and a day after this case will be closed down. There may be cases where the Court of Appeal would have taken a different view and decided that judicial review was appropriate. I had been going to bring the Court to some other references, and maybe rather than taking up time with them, if I could just provide the Court to some references about some of the backdrop points and then move from that. So you can see the first response on the part of my client to the letters from the appellant's solicitors, whether they were on her behalf or not, is at page 756. That's a letter dated the 29th of March. It specifically draws attention to the fact that your clients may direct their attention to the operator itself. Then they also in that letter set out the steps that have been undertaken at that stage by Lisburn Council to look into this issue in a general sense of odour from mulliclass, and perhaps come back to that shortly. Then there's the judicial review pre-action letter, which Lady Simler referred to earlier. That's at 759, and the response to that of the 7th of May is at 820. And out of interest, you can see Belfast City Council's papal response of the 30th of April at 884. And as my learned friend McLean's already referred to, it referred to the Section 70 route in stark terms as an alternative remedy available to the applicant. And similarly then my clients, there was a letter on behalf of my clients at page 343 in the core bundle, 25th of June 2021, where again a specific reference to Section 70 as an alternative remedy is flagged up. And the appellant responded to that, the response on her behalf, on the 2nd of July. And that's at page 345, and it might be worth just very briefly having a
345.
345 in order, yes. And if your lordships and lady have that, actually in 346 on the second page of that penultimate paragraph, you can see the response made on behalf of the appellant's solicitors, which respectfully we say encapsulates the key issue in this case, which is what actually is the issue at hand about. And the clear difference and distinction between the two sides on this case and this issue is, on the one hand, if one might say it, and I don't mean this in any pejorative way, of course, a technocratic approach on the part of the appellant, looking to that inflection issue, intermediate issue, about what are the state bodies doing about this, as opposed to the stand-back, holistic, we respectfully say pragmatic and common sense approach, which is then encapsulated by the Court of Appeal in its decision, whereby it says, let's cut to the chase. The real issue here is the nuisance. What's the best way of getting to the problem and solving it? Because one of the key issues that will come out on any review of the case law in respect of alternative remedy is the efficacy of the alternative remedy. And why we say that's of particular relevance in this case is that even if the appellant had succeeded against my clients, the council in the High Court or substantively in the Court of Appeal, and been carried shoulder high from the court, having successfully shown that in fact the council had not discharged their statutory duty fully, was that going to result in a situation whereby they had in their hands an order of mandamus ordering the issuing of an abatement notice? And respectfully we say that that is so unlikely as to be something that the court could entirely discount. The most they were going to achieve would be putting matters back to square one and requiring the council to undertake their investigations afresh. Meanwhile, the odour problem continues to exist. The statutory nuisance is still there, and the appellant, having succeeded on the inflection point, is really no better off. They're still faced with the odour problem. So,
could I just fully understand that? Not better off. It is surely a little bit better off, because the council would then comply, would follow, having been told what his duty was, would actually get on with doing something.
well, yes,
And so, did I hear you correctly, that the applicant would not be better off?
in no meaningful way, because the mere fact that the council had been hypothetically found to be in breach of their statutory duty, and primarily here.
Why do you say it's hypothetical?
Because the High Court didn't do that. So I'm thinking of a situation where if that
we're
did
in
happen,
a counterfactual.
Exactly. If we were in,
but on your counterfactual,
Yeah,
they would have
yeah.
been found in breach of their duty.
Yes.
And as Lord Stevens says, that is meaningful, Because you would expect the council, having been found to be in breach of their duty, to take their responsibilities more seriously and
undoubtedly,
act
lady.
in accordance with what the court has said.
Undoubtedly, and I wouldn't try to suggest otherwise, and in fact, that would be quite wrong for the
So
council
why
to do
isn't it
otherwise.
meaningful?
It's not. It might. It's maybe could be described as a difference without a distinction, or a distinction without a difference. It's not meaningful in the overall sense of actually bringing the statutory nuisance to an end, because
Well, it certainly is, Mr. Cole, because if the council were found to have not conducted their duties correctly in relation to statutory nuisance, then they would have an obligation to get on with it and stop the statutory nuisance if there was one.
well, what
So,
they're required to do.
one frequently during the course of oral hearings makes submissions that, on reflection, perhaps aren't necessarily appropriate. But are you really suggesting that she would be not better off if there was a declaration from the High Court against the council?
Well, yes, well, I'm not trying. That's not to denigrate the importance of a declaration from the High Court. What I'm saying is, as a matter of factual reality, the particular complaint effectively levelled by the appellant against my client is in a vague kind of way that it didn't do enough. As we know from earlier, when asked what more it could have done, there is really no answer. But
that's going to the merits. We're dealing with a separate issue now,
okay.
And that is the alternative remedy. And you're saying, well, you can go down the route of getting a declaration against the council, but you're no better off after that. And I really have difficulty in following that.
Well, I don't mean to use a colloquialism or double down on that point, but I have said what I've said, and what I mean by that is meaningful in the sense of changing the overall picture for the appellant. So if she had gone to the Magistrates Court under Section 70 and obtained an order from the Magistrates Court requiring the operator of the site to take remedial action, then that would be a meaningful outcome. Obtaining an order from the High Court that Lisburn and Castlereagh City Council had not properly discharged its duty is not meaningful by itself, because all it means is the council then, yes, has to go back and look again at what it's going to do, but it doesn't mean that the end outcome will be any different. It certainly doesn't mean, and this court can't take from that there would have been, as an inevitable outcome, the issuing of an abatement notice, much less then subsequently a failure to comply with it and a prosecution arising from that. So the system that envisages the regulator taking precedence and pushing this problem across the line to solution is more layered than the approach under Section 70. And that's why we say there is a difference and a more effective remedy in the particular circumstances of this case. And if I could just, I think conscious of time, I'm probably going to have to maybe just give the court some more references and then move to some of the legal points that I wanted to try to draw out. So I'd ask the court to consider in due course the affidavit evidence of Ms Courtney on behalf of the council, and that's found at EF 2209.
Sorry, what page?
2209, my lord.
Right.
And then also to gauge this against the Order 53 statement and what's actually alleged in respect of my client. And you see that in its original format in the core bundle at page 282. And in particular, draw the court's attention to paragraphs 3.1 Romans 3 and 4.1 Romans 17.
Sorry, 4.1.
4.1, Lord, yes.
Little Roman?
Romans 17, Lord.
17.
17. And then in the final version, the re-amended version at core bundle EF 370, in respect of my client, it's in effectively the same terms, not exactly the same terms, but in effectively the same terms as the original. And so if then I could turn to some of the issues relating to the authorities. I wanted to make reference in particular to three, and I think, conscious of the time, we'll try to do this in a consolidated fashion. So I asked the court to pay particular attention to Glencore, which obviously the court's very well aware of. That's in Authorities Bundle 1, page 4763. Ballyedmond, again in Authorities Bundle 1 at 4756. And Alpha, the Court of Appeal of Northern Ireland's decision in Alpha at Authorities Bundle 1, 4738. And there's a series drawing from those authorities in particular, there's a series of effectively bullet points that I'd like to set out to the court that we consider are very important in understanding the legal nexus within which the Court of Appeal made its decision. So firstly, this is not suggested as an oyster of the High Court's supervisory role. As we've said, it's simply a question of discretion as to whether to refuse to proceed with the judicial review, looking at the overall factual context. Then a reminder, if one is required, that judicial review is very much a remedy of last resort to ensure that the rule of law is respected. But the rule of law, of course, we respectfully say, is also recognised and protected by other legal processes, and specifically in this case by the legal process that would address nuisance, either the statutory process or the common law process of public nuisance. Suitability of alternative remedy consideration must be given to the legislative choice that has been imposed in the field. Now, that will not necessarily, in the absence of an oyster clause, that will not, of course, necessarily be determinative or final, but it is, we respectfully say, highly relevant to how the court considers the question of alternative remedy, where statutorily the Assembly has constructed a careful and complex scheme. Is it a direct equivalent to judicial review? Plainly not. But is it something that's relevant to the question of whether it's necessary and appropriate for the court to consider continuing with the judicial review? We say that it is highly relevant. There is a need to avoid expensive duplication of effort regarding what's described in Glencore paragraph 56 as, and put some emphasis on this word, the same underlying subject matter. So here that might be a question of how one considers what the subject matter is. But interestingly, in Lord Sale's judgment in Glencore paragraph 56, the word underlying, we say, is there to serve a specific purpose. So arguably one could say that the judicial review proceedings are not the same subject matter as the statutory nuisance procedure or indeed the civil procedure. And one might consider, on one reading of it, that there is an argument to be made in that regard. We don't necessarily accept that, but we say that the inclusion of the word underlying subject matter is quite telling, because respectfully we submit that what else could be seen as the underlying subject matter here other than the statutory nuisance? And indeed the appellant in terms accepts that to be the case, because the appellant's point is that they want the regulator to take action that removes the statutory nuisance. The statutory nuisance is the omnipresent aspect of all of this. It is the underlying subject matter. Another factor the court might take account of and this is perhaps a scene at Ballyedmond at page 4761. It's my word for it, not the Court of Appeal's word for it, but effectively the triangulation of interests. That the public has an interest in how the legal processes in this jurisdiction are seen through. And that's a complex matter. It involves the High Court in judicial review being freed up to be highly responsive to those cases where there is absolute need in the protection of the rule of law for High Court action to be taken expeditiously. So the triangulation of interests involving the public as well as the parties to any judicial review is of, we say, key importance. And that's related to matters such that you see referenced in these authorities also about the need for speed, the need to consider the impact on public health, the need to consider expense, finality, and also, crucially in this case, fact-finding. And essentially that's for the court to ask the question, is this the venue best able to address issues to do with the finding of fact? And plainly,
if I may make this point, if it's a judicial review claim, a different set of factual investigations are called for than if it's a statutory nuisance claim. So here, the judicial review claim is to the effect that the public authorities have not properly fulfilled their duties by making inquiries and so on. Now, there's a certain set of factual evidence that will go to those questions, and usually it will be the public authorities' evidence which is, in effect, taken as determinative on that sort of question. That's very different from the sort of question that would arise in a full Section 70 procedure, where you would have a direct contest, not with the public authority, but between the individual and the operator, in which there would be a determination as to whose expert was the better expert, giving better evidence about best appropriate techniques and so on.
Yes, well, I think what I would say about that, Lord, is that at best there's probably only a degree of overlap between the two factual experiences or considerations, and that the Lord, if I may respectfully say, is obviously quite right to identify that the task in judicial review, looking to what the public authorities have done or not done, is not going to be the same task as undertaken elsewhere, and certainly wouldn't be determinative of the issue of the existence of statutory nuisance. And in fact, that comes back to the point I was making earlier about the limitation of the judicial review as brought, because it actually isn't in a position to get to the key issue as to whether there is a statutory nuisance. It can only get to the issues of what have the state parties done to ascertain if there's a statutory nuisance. The two are not necessarily the same thing. So I respectfully don't disagree with my Lord's point, but I try to take it and develop it as meaning that it actually points
I was picking up on something you said. You said, in relation to fact-finding, is this the appropriate venue of mini judicial review? Well, whether it's the appropriate venue depends upon what questions are being asked, and if it's judicial review, it is the appropriate venue, but it's just that a particular approach to fact-finding of relevant facts for that question is adopted, which is different from the facts which would need to be found in a Section 70 application.
Well, I think the point, though, identified both in first instance by Mr. Justice Humphreys and by the Court of Appeal, was that in the particular circumstances of this case, there's going to be a need, in order to be able to get, for the appellant to get home in the judicial review, there was going to need to be a consideration of factually disputed material. How that plays out for an applicant in judicial review, as we know, and indeed some discourse about it with my learned friend Mr. Suddy this morning, is that very often that means, well, tough luck to the applicant. If there's a dispute on the evidence in judicial review, it will normally be interpreted in favour of the respondent.
Yeah, I'm not sure I put it in terms of tough luck to the applicant. It's completely fair to the applicant, having regard to the question that arises in judicial review.
And that's really the point I'm going to come to, my Lord. I think hopefully an answer of your Lordship's point, whether it is or not, remains to be seen. If the court could turn to page 218 in the core bundle, and this is the Court of Appeal judgment, and at paragraph 42. Lord Justice Horner said as follows: in the present judicial review application, given that the experts on each side remain irredeemably divided, the only course the court could take would be to accept the expert evidence filed on behalf of the respondents, who did not have the onus of proof. If the expert evidence is approached in this manner, the whole basis of the appellant's case is fatally undermined. We consider that this would be an unsatisfactory way of resolving the contentious scientific debate put before this court.
Well,
it is
difficulty with that last sentence because.
So would I.
So do I.
Sorry, I'm not sure which justice to turn to first.
Lord Sales is the justice to turn to.
All right, I'll make my point, and Lord Stevens can add his. So the last sentence, it's not the court's role in judicial review to resolve the contentious scientific debate put before the court. That just, to my mind, seems to be a misconception of the court's role.
I think, my Lord, actually, probably the better way to look at that is, again, it's part of this picture of the Court of Appeal standing back and looking at the bigger picture. So what Lord Justice Horner is saying here is that, yes, you could proceed with this as a judicial review, and there would be an almost inevitable outcome in terms of how that factual dispute, to the extent there is one, will work out. And as he says, as the judge says, it will almost inevitably have to go against the applicant. And really, what I see respectfully from that last sentence in paragraph 42 is the judge saying that's really unsatisfactory in the overall scheme of things, because the appellant is then going to come away from it thinking, well, the legal system has not grappled with the issue as to what the scientific evidence says about the public health implications that Mulla Glass is having for me, my family and my community. And that it's part of the court's grappling with that bigger ticket issue, which is to say, yes, you could go through the technocratic and perhaps tunnel vision approach of bringing the judicial review, putting all the effort and resources into that, including financial resources and court time resources into dealing with the judicial review, to end up in a situation whereby the underlying key issue remains open, because the real means by which it can be addressed, to use the phrase, the underlying subject matter can be addressed, is by either the statutory nuisance process and or the civil courts in a common law nuisance action. And that was at least a key part of the court's thinking as to how that should be developed. And we see some authority, be it primarily Ballydedmond, Northern Ireland Court of Appeal decision from some time ago, but the difficulty in fact-finding, but also, and you can see that 4761 of the electronic pages, the need to stand back and consider what's the scope of inquiry in this case. So,
but who decides the scope of inquiry? If the claimant says, or the individual says, my claim is about enforcing the regulatory obligations of these three public bodies, is it for the court to substitute its view of what the scope of inquiry is? Or should the court look at what the claim actually is and say, well, on judicial review, we're not going to have to resolve the expert evidence. We're going to have to look at what these three public bodies did. Did they carry out a sufficient investigation? Did they respond adequately to the expert evidence they obtained? And did they act within the powers and sufficiently under their statutory duties. That's the scope of the inquiry. Can that inquiry be done elsewhere? No. Judicial review is the place to deal with the scope of that inquiry. That's what's being said.
In a traditional sense, yes, lady, that's right. But what the Court of Appeal has done is to, as I've put it perhaps inelegantly, is to stand back and look to that bigger picture. And it's looking to what's actually required here to the benefit of the appellant. Is it this potential inflection win, or is it something beyond that? And of course, we also know that in the court, in coming to its decision, through no fault of its own, the court was dealing with that at a stage where there had already been the High Court judgment, where facts had been found about what the state parties had done. If one considers the notice of appeal, the Court of Appeal, which is not asked the court to turn up now, it's at 5:20. Certainly in relation to my client, there's no suggestion of any, to the extent this could be done in any event, challenge to the facts as found by Mr. Justice Humphreys in relating to what my client had done in conducting investigations. So the Court of Appeal is armed with all of that information, and it can only make a decision based on the context in which it finds itself. Ordinarily, one might, as a purist, consider that these are the sort of decisions that are to be made at the leave stage at the High Court. But for the reasons my learned friend has outlined, it simply didn't present itself as an opportunity, and that's not the way matters developed. But it's not to say that the Court of Appeal is then hidebound by that and left to say, well, in some kind of way we've been placed into the straitjacket of the claim that has been brought by the appellant, and that we are not entitled to look outside of that in the exercise of our discretion as to whether there is an effective alternative remedy. And I suppose in the final analysis it really comes back to this point of what's the underlying subject matter in this case. Is the underlying subject matter just to be looked at in the restricted or limited fashion, saying it's just simply the judicial review that's brought, or is it within the discretion of, as it was, the Court of Appeal to consider, well, actually there's a bigger issue here, and there's a better and different way of seeing that bigger issue to completion. And an element of that, of course, also involves the court's consideration of the allocation of judicial resources, cost and convenience. And you see the Court of Appeal in its judgment talks about that, not at great length, but it certainly makes some key points in respect of it.
Mr. Cole, I'm sorry for taking you back to that final sentence, but to my mind, the last sentence, an unsatisfactory way of resolving the judicial review, would be an entirely orthodox and proper approach to resolve the judicial review in that way. It resolves the public law issue, and it's certainly not binding in any civil proceedings, which may be brought by the applicant against the private individual. It resolves one issue, that is, whether the regulator has acted appropriately. And so I consider that there's conflation there of two sets of proceedings. It's certainly an unsatisfactory way of resolving a scientific debate, but that's not what judicial review is about. You don't resolve a scientific debate.
And indeed,
and you can do so in civil proceedings or indeed under Section 70 if you want to.
yes.
But this debate is entirely different from that. And it's resolved perfectly appropriately by saying the respondent's evidence wins.
Well, my Lord, I think, essentially that was what Mr. Justice Humphreys said in the High Court when he looked at, he said that the Section 70 process effectively runs in parallel to the judicial review. The two might have some common issues behind them, but that they are separate strands and they're achieving and aiming at different things. I think, I'm not sure necessarily, respectfully, they would agree that what the Court of Appeal did, and by way of the last sentence of 42, that it's conflated two different issues. respectfully, what we say the court has done is to say there are two separate issues, and in fact, the underlying subject matter point is more important, and we're considering in the exercise of judicial discretion that the efforts of the parties should be focused on that, not on the judicial review. And largely that's because the judicial review process has its limitations that I've outlined and talked about earlier, and that actually the Section 70 route provides a more efficacious way of achieving the end just result that the appellant seeks. And my learned friend...
if I may just take you up on that, the judicial review procedure does not have limitations, as you put it, if what you're concerned about is resolving the issue in the judicial review proceedings. The judicial review procedure is exactly honed to achieving that end. If you're trying to use it to resolve some different issue, yes, it all falls apart, but that's because you've lost sight of what question the legal proceedings are addressing.
Yeah. Yes, Lord, I don't take issue with that. I mean, a prime example of that, for example, would be in this field, if, for example, there'd been an attempt to bring a judicial review against Alpha as a non-public body, and there may have been jockey club type issues about whether, in fact, it's in zone for judicial review. So yes, the judicial review process can achieve a suitable and end outcome depending on what it's aiming at. I think our point in common with the Court of Appeal is that it's the wrong target in this case, and the Court of Appeal considered...
Can I take you up on that? It seems to me it's an entirely logical target from the point of view of the appellant. What she's seeking to do by the judicial review is recruit the regulators to take action, enforcement action, which will have an outcome which she is seeking to promote, namely stopping something which is a great annoyance to her. There's nothing illogical about that. Indeed, it seems to me entirely logical. Why should she have to incur the cost and expense and risk of taking proceedings herself under Section 70 if it is the case that that's what the regulator ought to be doing?
Well, she has to, in bringing the judicial review, she's also engaging in risk and
certainly
exposing herself to costs, etc., in the same way. And
well, you say in the same way. Judicial review is supposed to be a speedy and efficacious process. That's one reason why one doesn't have witnesses in the witness box, because the questions are much more focused than they would be if you had to have a resolution of the contentious scientific debate, to use the Court of Appeal's language at paragraph 42. So the cost consequences, at least in theory, may be far greater if the appellant went down the Section 70 route herself.
Well, one might say, Lord, the Section 70 route, of course, that the Assembly, in its wisdom, has set the venue for that as being in the Magistrates' Court, a court of summary jurisdiction.
But it still has to proceed on the basis of evidence.
Well, of course, Lord, yes. But in the final analysis, in all likelihood, whichever route was taken in this case, it's more than likely going to end up that evidential issues would have to be thrashed out. One certainly couldn't rule that out. So even if the judicial review route had been fully developed by the Court of Appeal, and if the appellant had succeeded substantively in the Court of Appeal, as I've said earlier, it only brings the appellant so far. It doesn't, as a result of that, get an abatement notice, much less a prosecution of Alpha, that's the operator of Mullet Glass. So there are various inflection points along the way, and what the Assembly has done is to create a system in a court of summary jurisdiction to allow these matters to be addressed, and there's no reason to suspect that they couldn't be addressed in a speedy, cost-efficient and expeditious fashion in the Magistrates' Court.
Yes, thank you.
My learned friends, I'm conscious of the time my Lords.
I think you're up to the limit, really.
If I can try to make just perhaps one very final point. My learned friends, in their written case particularly, my learned friends for the appellants, suggest that, and I'm paraphrasing here obviously, but that there's a great risk in going down this route, that there will be a negative impact on the rule of law and accountability for public bodies into the future in this field. And we respectfully say that that is a risk that has perhaps had much made of it and without a great deal of substance. For example, in those authorities which I've referred to, particularly in Glencore, it respectfully is clear that where there is an alternative mechanism, it will not be necessary in every single case for every error on the part of state bodies to be thrashed out in judicial review. If the facts of this case were different, if there was a suggestion, for example, of something seriously untoward at hand, a fundamental and egregious breach of statutory duty, something that reflected a policy, or something that suggested even something more notorious than that, then one might imagine that the Court of Appeal's decision could well have been different. And the Court of Appeal might have said, well, this is actually territory whereby judicial review, to get to the bottom of that, would be important. But essentially, in creating the alternative statutory regime, the Assembly is recognising that it will not be necessary in every single case to go to the nth degree of judicial review, and that that will not by itself mark some fundamental breach of the requirements of the rule of law. There's also, I think, a point to be made about alternative means by which accountability can be achieved. And I'm out of time in respect to this.
You are out of
time. Could I? Well, I'm subject to the court.
In two sentences.
Okay. So there is the opportunity for political accountability in relation to my client in particular. My client's a local district council. Its political representatives are very close to the people, and if there are issues of difficulty arising in respect of the discharge of its duties, then those political representatives are well placed to deal with it. Secondly and finally, there has been some discussion about the Public Services Ombudsman, and when our friend was asked, Dr. McAleenon was asked whether he was relying upon that. He was perhaps somewhat diffident in his approach to that. I'm prepared to be slightly...
He was more than diffident, he said he was not.
Well, even more than that then. I perhaps am in a position to take a slightly different approach in respect to that. We consider that, in fact, there is, in many of the occasions where this type of issue would arise, a place for the Public Service Ombudsman in maladministration consideration. And my learned friends in their written case have set out in the Bradford case, and you find that at 5982 of the bundle, and at 6006 of the bundle, you can see some of the features set out there of maladministration. And I would respectfully ask the court to consider that those are exactly the type of matters that arise in this kind of territory.
Thank you, Mr. Cole.
I thank you, Lord. I'm grateful, Lord, for the patience to allow me a little bit of extra time.
Thank you very much. We're grateful to you. Mr. Sully.
Thank you, my lords and my lady. Can I start by just giving a couple of references, really? The first was in response to a question my Lord Stevens asked this morning, which was about the location of the Jerome monitor. There are a series of reports. The ones we were able to locate over lunch are at 2729 and 2734 of the bundle. But to use one example from the 2729, which was the first set of Jerome meter monitoring occasions, monitoring included, there were 4 sites, one of which was a sort of meant to be a dummy site, albeit it was close to the site. But the others were away from the site, and so, for example, one was in an area called Mount Eagles Play Park, which was obviously in the middle of a residential area, and you could see that from the map. Secondly, in terms of the evidence of Ms Courtney that Mr Cole referenced, could I ask the court to consider in particular the paragraphs 23 and 25 with care? 23 is...
Sorry, which page is this?
Sorry, 2215. Sorry.
Sorry,
2215.
2215.
2215, I think that's right.
It is, yeah.
So, yes, the relevant passages are at 2215.
Yep.
Paragraph 23 is where her evidence is about how the appellant's first complaint to the council was dealt with, and it was simply referenced to the agency, the Northern Ireland Environment Agency. And para 25 is the chronology, and you'll see that, for example, odour diaries start on the 10th of March 2021. Odour monitoring by the council starts on the 22nd of April 2021, and that's why, in opening, one of the points I was making was that this issue of misdirection goes to historic compliance, because the paragraph of the judgment of Mr Justice Humphreys that was put to me is very much about the point of time when the hearing takes place in the High Court. It is not necessary, and that's why I was talking about historic breaches. And can I then turn to the issue of the substantive arguments? There was, from my learned friends, in one sense, very little said about the substantive arguments. Dr McAleenon did engage with this point about the guidance that we say has been adopted in England, and his argument in relation to that was to say, firstly, that guidance about lifetime exposure was effectively unreliable because it was a single study. The problem with that in our submission...
Sorry, I thought at the prior stage it was disputed that it was guidance at all. It hadn't been adopted in England.
Well, can I come on to that point? I was going to deal with it in the opposite order, but I will come on to it. But he made 2 points, essentially. The second was about whether it had been adopted in England and Wales, and I'll come on to that. The first was that he essentially said it was an unreliable standard. But, of course, the problem with that is if you knock that standard out, there is simply no other standard. My learned friend fairly accepted that. Now, he says, essentially, that it's not been applied in England and Wales.
Sorry, just on that, there were other standards in the document you showed us. There are a series of standards. You happened to pick upon the one that suited you. There were others as well. But I think I'm right in saying that one of the witnesses in their affidavit went through looking at the health risks and concluded that in their view, there was no health risk.
Well, 2 points about that. I think, firstly, there were other standards in that document, but they were dealing with different issues. One was about long-term lifetime exposure, one was about medium-term exposure, and one was about short-term, very short-term exposure. And unsurprisingly, what they were saying was effectively we've adopted a lower standard for lifetime exposure, and that's what we were, to a large extent, focused on, because we were talking about long-term residence. Or the appellant was focused on, because it was talking about long-term residence. The passage I think my Lord is referring to in terms of the safety is the passage I think from Dr. Cromie that there was. I made
paragraph 14, page 4036.
That may well be what I'm thinking about, my Lord. Can I just? Yeah.
So I think he'd done an exercise in his. This is his second affidavit, I think, isn't it? I think he'd done an exercise in his first affidavit as well.
But my Lord, the point I made about that is he refers to, and it's at the end of paragraph A, that's concerned with levels for established short-term health effects. So he's what he appears to be engaging with, and it's unclear. I can't remember whether this is, in any event, predates his engagement with the Richard's evidence. I'm not sure at this stage he does. But anyway, but what he appears to be focusing on, which is it's accepted. No, sorry, he does deal with the 1 part per billion because he deals with it later on. What he's dealing with there is, on the face of it, a different issue, which is whether the evidence indicated, or certainly the material from England indicated, there were potential issues, which is short-term exposure to high levels. He deals with the particular issue of the 1 part per billion at paragraph 22, the lifetime exposure, and he distinguishes that simply on the basis that the risk assessment essentially was particular to Wally's quarry. What he doesn't deal with there is engage with the issue that I was raising, which is what is effectively the safe limit for long-term exposure. Now, my learned friend Dr. McAleenon went on to say this had never applied in the UK. It's important to recognise that there are two distinct potential issues here.
Sorry, just on that, doesn't he address that in paragraph 22b?
Yeah.
Sorry, I just closed the page. My lord, could you...
4038, page 22b, and we go back to the experts that perhaps not unreasonably have been asked to give an opinion. They say Tetra Tech has not indicated any cause for concern in relation to 1.3 ppb level as an average likely over a period of 365 plus days.
But there are two. The problem. The answer to that is he is still not engaging with what is a safe long-term level of exposure. Is he saying 1 part per billion or 1.3 parts per billion is a safe level or not? In circumstances where, yes, Tetra Tech suggested there wasn't a problem, but the material that he himself had referred to, because it was obtained by his own agency, which was the issue, the readings from the Jerome meter, suggested higher level. And the problem, the fundamental problem here in my submission is the point that Lord Stevens put to me, is they're carrying out various monitoring tests. They're carrying out the Jerome meter. The council has engaged Tetra Tech, etc. They're producing different results, but nobody's actually thinking what is it we're actually aiming for? What should be our level of concern? But Lord, the other point I need to deal with is this point that the 1.1 part per billion or 1.3 part per billion level had never been applied in the UK. It's important to recognise that what Mr. Justice Humphrey said, or concluded in paragraph 79, which my learned friend relies upon, is that there was no standard in the permit. That's what paragraph 79 says. However, and this was not in dispute, what you see in relation to Wally's quarry is that the regulation, more general regulation, because of course it's not just the permit in reality, it's not just the permit that is used to regulate. Regulation can occur in various forms, includes ultimately withdrawing a permit, for example. Wally's quarry shows, the material shows, that the regulator there was assessing Wally's quarry performance against a standard for long-term exposure. It was doing that against, in particular, the 1 part per billion. It wasn't including it as a condition in its permit. The Order 53, paragraph 4A, complained generally about the failure to engage with this. And I come back to the fundamental point in relation to this, which is the Northern Ireland Environment Agency, the second and third respondents, at no point identified what is, in their view, a safe level for long-term exposure. My learned friend accepts that. And if you're going to carry out a monitoring exercise in our submission, you've got to know what is risky. And risks obviously can occur in different ways. Short-term exposure can be very unpleasant, but can it was obviously brought to an end in a short period of time. Long-term exposure can have different health effects, and that was what was being was the underlying concern that was addressed in the Wally's Quarry regulation by monitoring against a long-term standard as well as a short-term standard. And in Northern Ireland, there was no understanding of what it was, whether it was 1 part per billion, some higher limit level, some lower level. There was no attempt to work out what was the risk. A regulation was taking place in this vacuum, so that we're getting a range of results. The Jerome meter suggesting higher limit levels, Tetra Tech suggesting lower levels. There was a range of results that that were being assessed, but it was unclear, in one sense, what was seen as safe. And so we do submit that in these circumstances where fundamentally we would say in relation to ground 2 the issue for the court is whether or not this matter should be remitted because there hasn't been full argument, in circumstances where my learned friend's submissions actually on the underlying merits were limited, in circumstances where there is this issue, and obviously the court's had open to it relatively limited evidence about what the testing showed, this is a matter that is worthy of consideration, particularly when there is also the issue of the historic treatment and as I say, the issues that potentially arise in relation to the changes that took place during the course of this litigation. Turning then to the substance and in particular the alternative remedy, in my submission, what my learned friend's submissions ultimately came down to was that this was ultimately an issue of discretion and case management. The problem with that in our submission is that it ultimately extends case management well beyond essentially what is traditionally known as in relation to case management, because it allows effectively the court to decline to hear an argument properly put before it. And remember, in relation to this case, leave was granted to apply for judicial review. Not only that, when the Order 53 was amended, there was substantive argument about the amendments and whether that properly was arguable in light of Richards. And then it came to the Court of Appeal as of right, which is a policy choice of those who make the rules in Northern Ireland. So it was a case that was properly before the court. And there's been a certain amount in that context of argument about paragraph 42 of the Court of Appeal's judgment, which is the point about the case being fatally undermined. Obviously adopt some of the remarks of the court in relation to that. But there is also a more fundamental point about that paragraph 42. That was essentially an assessment of the merits of the case in circumstances where there'd been no argument about the merits of the case. The court expressly at the start of the hearing said, we will only hear you on alternative remedy and whether this case is academic. And so there was it was the court saying this case is bound to fail in circumstances where it actually hadn't heard any argument about that. And that's a matter of principle. That can't be right. And that demonstrates the problem. Now, had the court said, we have concerns about the merits of this case, we want to hear you on the merits summarily to decide whether or not it's a sensible deployment of time to hear longer argument, that might be a different thing. There are things that can be done in terms of case management to ensure effective use of resources. The point my Lord Sales made about how judicial review has inherent controls to ensure an appropriate deployment of resources we would adopt. But the fundamental point here is the court was, to the extent it was basing its decision on an assessment of the merits, it was doing that without any argument at all, and that can't be right. And that's why, in our submission, there is an issue here about access to the courts. There was an issue that the appellant properly wished to have resolved on the merits. She hadn't delayed, she hadn't committed any of the faults that potentially allow someone to be struck out, but she was prevented from doing that on the basis she could bring an alternative form of proceedings against a different defendant raising different arguments, and that can't be right as a matter of basic principle in our submissions. That broadly claims, there are obviously details that I could potentially go into in relation to the arguments about alternative remedy, but I think they've largely been canvassed. One final point I'd make about the case being academic, which was really only addressed by my learned friend Dr. McAleenon. He says, well, there have been limited complaints about odour, and that demonstrates the case is academic. Without sort of repeating what I've already said, we've drawn attention to the fact that the health harm isn't necessarily linked to odour, depending on level you assess harm potentially being caused at. The fact of the matter is, which is the approach of the Court of Appeal, and we submit on this issue, the Court of Appeal was right. The Court of Appeal recognised that there was no evidence suggesting that that there would be no emissions of gas. Capture wasn't perfect. That hasn't changed. There is still, under the legislation, a role for both regulators to play. Parliament's rather I should say the Northern Ireland Assembly's choice is that the regulators have a role to play, and in those circumstances it's legitimate to seek enforcement of that role, and it remains legitimate to seek enforcement of that role, and that's one of the reasons why historic findings are potentially of importance. It's not simply about damages. Historic findings serve a public function because they record essentially the fact that a regulator has failed to appreciate the full extent of its legal responsibilities. Again, I'm slightly ahead of time. Can I just turn round to those behind me? Of course. I've had the sign-off from those with the real power, so I have nothing else to say unless there are any questions.
Thank you, Mr. Southey. Well, we're very grateful to you, Mr. Southey, and to Mr. McAleenon and Mr. Call, and to your juniors, also to those sitting behind you who've played an important part in preparing this matter for the appeal hearing. We're very grateful. We will take time to consider our decision. The court will now adjourn. Thank you all very much.